Hi, my name is Travis Torme, and I'm a criminal defense lawyer in New Jersey. Today I'm going to talk to you about restraining orders. I'm going to give you some general information about them, and then I'm going to tell you about the 3 best ways I defend against a restraining order. The first thing that happens in a restraining order case is a temporary restraining order is issued. This means that a superior court judge signed a temporary restraining order against you, prohibiting you from going near the alleged victim. They also can prevent you from going near their work, their parents' house, where your kids go to school, or any other places that are designated in the order. This means that you have to stay away from this person until the final restraining order hearing is held in court. At this point, the judge will determine whether or not a permanent restraining order should issue. Remember, a temporary restraining order is granted as soon as the alleged victim files for it. Nothing has to be proven. Now, your opportunity to fight against these charges is done at the final restraining order hearing. This is where you can put on your defense and hopefully get the restraining order dismissed. At the final restraining order hearing, the alleged victim can testify. They also can admit any evidence that they want, including text messages, emails. They can have witnesses testify who had seen any interaction between the parties. And the judge will determine whether or not there is sufficient evidence for a permanent restraining order. After the alleged victim goes and puts their case on, it is now to the defendant's turn, the person who's defending against the restraining order. You can testify, you don't have to, but you also can admit any evidence you'd like. Text messages, emails. If you have defense witnesses who can combat what the other person said, obviously it'd be good for them to testify. At the end of it all, the judge will determine if there are grounds for a permanent restraining order. If a restraining order is issued, then you will be placed in a statewide database. You will be fingerprinted and put in a database, and you are not allowed, obviously, to go anywhere near this person. If you do, you can be charged criminally with contempt and face up to 6 months in the county jail. Now, it's important to remember that a restraining order is not a criminal charge, so this will not show up on a background check. It's not on your criminal record. However, like I said, if you violate the order, there can be serious consequences. On the other hand, if the judge does not find grounds for a final restraining order, then the restraining order is dismissed. All the restraints are gone, you can go wherever you want, and you don't have to worry about running into this person and potentially getting charged with criminal contempt. If you'd like to see the 3 ways that I attack and potentially defeat restraining order cases in court, click the links below. Each one of these links will send you to a different video with a different defense strategy. You can also visit my website. It's www.criminallawyerinnj.com. My contact information is listed on the website, and I'm happy to talk to you anytime for a free initial consultation.